I'm Florence Brocklesby, Bellevue Law's founder, and this is the start of a special season of the Bellevue Brief, where members of our workplace law team are going to be tackling the Employment Rights Act, explaining some of its key provisions and discussing what employers should be doing now and what they should have on their horizons as it rolls out across the next couple of years. The Act is going to result in a raft of changes, and there is a huge amount, possibly an overwhelming amount of information circulating about it. So our aim in this series is to share short episodes with clear explanations of what each change means for employers and practical advice about what they should be doing to roll them out. And so with that in mind, I'm very pleased indeed to be joined today by Bellevue Law's Chief Operating Officer, Kate Osborne, because Bellevue Law is not just a legal advisor, it's also an employer. And we thought it would be helpful to discuss what we're doing as a business to prepare for and to action these changes. So, Kay, welcome to the Bellevue Brief.
Thank you, Florence. Lovely to be here. With the practical in mind, in this first episode, we're going to take a step back from what the legal changes will be and look at how employers should be approaching implementation to ensure a smooth rollout, protect against new legal risks, and even see commercial benefits from updated processes and practices. And I'm really pleased we're starting this season with this topic because it's the part that determines whether employers will roll out the changes they need smoothly or end up firefighting with increased legal risk.
So, Kay, to get started, can you summarise how employers might want to approach implementation of the Employment Rights Act reforms and indeed how we're doing that in our own business?
Yes, of course. I think there are three key takeaways. Firstly, this is essentially a major change management project, and it's important to treat it as such and ensure there are adequate levels of resource and commitment. Secondly, employers need to understand the key risks from the ERA for their own businesses in a bespoke way. There may be some key strategic decisions which need to be made well in advance of changes coming in. And then there is the project management piece, auditing current documents and practices, monitoring critical dates and planning updates, training and support. And I'll say more about this later, but for many employers, it's also about thinking about HR systems and processes and whether they are fit for purpose.
Okay, so that's quite clear. It's resourcing, it's risk assessment, and it's the nitty-gritty of implementing a change management project.
That's right.
So let's start with resourcing. What are we doing at Bellevue Law in order to get ready to roll out these employment law reforms?
Well, to be completely transparent, obviously we have some advantages in that we have a large team of employment lawyers. So many of our team already have an understanding of the significance of the Act. But nonetheless, there does need to be sponsorship from the top of the organisation. So it isn't just something that's seen to be owned by HR. In our firm, Florence, that means you. So knowing that you will support the key changes, that you will allow time for policies and practices to be reviewed and updated, and also to be available to make strategic decisions is key.
So just by way of example, you and we've already sat down and we've discussed what the changes will mean for our recruitment and our onboarding of new joiners. And we've made some changes. I think they were we had good processes already, but we've made some changes to tighten them up and improve them.
We have. So looking, for example, at the upcoming unfair dismissal changes, which means that employees can bring claims after 6 months of service, we've agreed to add an extra step to our own recruitment process to take care to make sure that we recruit the right people in the first place. We are intending to keep our probationary periods at 3 months with an option to extend if appropriate. And we'll also ensure that we obtain feedback from our team on all new hires from the outset. This will allow us to flag any issues constructively and in real time, giving new employees the information and support they need to perform at their best whilst also protecting the firm.
And Kate, to be fair, I think you've always been very good at that, but it's just a question of making sure that we tighten up processes where we need to keep to a strict timetable and that we're actively managing performance from day one.
That's right.
And we're going to have similar conversations about other policies in the coming weeks and months to make sure that we're getting ahead of other changes that are coming down the line as well.
So as well as that, Florence, we also have measures in place to comply with our Worker Protection Act duty to take reasonable steps to prevent sexual harassment. But I will be rolling out a number of additional measures to ensure we comply with the more onerous obligation to take all reasonable steps. This might, for example, include mandatory training, and it'll be much easier to make this happen smoothly with you championing it.
And I'm very happy to help. But of course, the bulk of the work is going to fall to you because
Indeed.
as our Chief Operating Officer, HR sits within your purview and it falls within your remit.
It does. And that's the case in every organisation. So someone or a team of people will need to take responsibility for creating and implementing the change plan. They need to have the time and the budget to do this properly. We at Bellevue, we've increased our operations team recently, and that's partly to support the growth of the firm. But it's also with projects like this in mind to make sure we have the resource and the time and the energy there to take that forwards.
And then in larger organisations, you're probably going to need to go one step further because it's not just about making sure that you've got HR resource, it's making sure that line managers who are going to have to implement some of these changes day to day, they need to make sure that they understand what their new obligations are, that they're trained and that they're supported around that as well.
That's right. And quite often where there are performance issues, they're not always fully understood by the employee because their managers want to be kind and nobody likes having these potentially awkward discussions and conversations. But actually, generally, it's fairer to the employee and it gives them the opportunity to address any issues that they have and receive support for those issues. It also protects the business and to have these constructive performance conversations in real time, it means that, steps can be taken. For many managers, however, they can't do this unless they are trained properly.
Yeah. So the line managers are the ones who are having to do it on the ground. And, perhaps one of the most important areas of training for them is not about what these legal changes are. It's actually the soft skills around how you manage performance, about performance management and about having difficult conversations.
I agree.
Which nobody's born knowing how to do that. But it's something that's going to be more and more important across all layers of an organisation going forward.
It really is, yes.
Thanks, Kay. That's great. So the second point that you mentioned was around risk assessments and how should employers be looking at this?
Okay, so this needs to be done on a bespoke basis. The ERA touches on so many different aspects of employment law. And so organisations really do need to be thinking about what their key legal, operational and financial risks are ahead of the implementation of the ERA. It's really important that the organisations really take that on board.
So can you give us a couple of examples of the kind of strategic risks that businesses and employers ought to be thinking about?
Yeah, of course. So one example is the removal of the cap on compensation for unfair dismissal claims. For employees with a number of highly paid employees in particular, instead of running best legal practice redundancy process, they may have previously relied on enhanced redundancy payments just to manage their risk. And this is something they may really need to rethink now. If your unfair dismissal exposure increases and isn't capped, you may need to invest more time in running stronger, more legally defensible processes with more rigorous selection processes involved, more time for consultation and, of course, more documentation.
Yeah, that's completely correct. And that's a topic that we're going to be going into more detail on in the next episode of the Bellevue Brief. We'll be looking at the changes to unfair dismissal law there.
So, another example, many employers should be focused on the effective ban on non-disclosure agreements or NDAs in relation particularly to allegations of discrimination and harassment. Historically, many employers have chosen to settle these types of claims under NDAs, but if that's no longer an option, organisations do need to employ a different strategy to address the fact that their practices may become public. So, for example, they could ensure that they are taking all reasonable steps to prevent the discrimination and harassment occurring in the first place, and also look at conducting robust investigations if complaints are made.
Yeah, and it's important to understand there that the reforms to NDAs are not going to come into force for a period of time,
No.
But when they do, they will probably apply to a number of complaints that are going through a grievance process or going through a whistleblowing process now, and a number of issues that are just beginning to come to the surface now. So when you're addressing those issues in the business now, you need to be looking down the road and thinking about when this comes to a resolution, it's possible that we won't be able to have an NDA as part of the terms of settlement of this potential dispute. So we need to make sure that we have that in mind in terms of how we address it now.
That's correct.
So we're going to have, again, another episode looking at the changes that the Employment Rights Act is going to make to the law around sexual harassment more generally, coming up later. But those are two very good examples of cases where employers need to be thinking quite strategically about what the changes mean, not just to policies and day-to-day practices, but to the way that they're approaching quite significant key issues in the business.
That's right. There is another example, and this one's more to illustrate the way changes should be considered by businesses in a bespoke way. And that relates to the example I talked about earlier about how we as a firm are strengthening our recruitment and probation processes. As part of that, we've really had to factor in the fact that our team work in a hybrid way. And so we need to really think about how we can manage performance effectively and fairly, despite not always being in the office face to face with people. This is obviously by no means unique to us as a business post-COVID, but it is an example of how the Act may provide businesses an opportunity to benefit from reviewing processes and practices and ensure that they are working in the best possible way for them, given their particular structure.
Yeah, that makes sense. So now we get into the nitty-gritty of rolling out change. And this needs to happen across every aspect almost of an organisation. I think you're touching on policies, touching on contracts, touching on day-to-day practices across the business. It's got financial implications. Tell us a little bit about what you would be looking to do in relation to that.
Okay, so this is where strong project management is key. You need a proper implementation plan with timelines, and you also need to make sure all of your key stakeholders are included in the project plan. I think we might be able to break this into 4 categories. So the first being documentation, the second, operational processes, third, people capabilities, and then finally, systems and data.
So, of course, we're reviewing and updating our contracts and our policies and to be fair, to be transparent, that's pretty straightforward for us because of the nature of our business and because we're also already been thinking about this for our own clients. So that's quite straightforward. But for most organisations, it's actually a reasonably significant piece of work, and it's something that you need to be thinking about doing ahead of time and potentially getting external support with as well.
That's right. And another key area is training. And it's not just HR, but line managers that need to have the training put in place for them. It will essentially be them that's putting together the policies and the processes into practice on the ground. And the organisation's success or failure in implementing the ERA will, to a large extent, depend on the understanding of these line managers and the wider organisation of what it is that's required of them and also the ability to be able to do it. It is a challenge. But it's also a really good opportunity to upskill managers in performance management, which should help drive better results for businesses, even if you do leave aside the question of legal risk.
Yeah, absolutely. And then let's talk a little bit about data. What are we doing with data in relation to this?
So there's a lot of data, and this needs to be monitored to ensure HR compliance. It's always been the case. There's always been a lot of data maintenance required, but perhaps now even more so. So it's not just the key dates for implementation, but also HR data. So, for example, tracking new hires' qualifying periods, keeping consistent performance records, and perhaps also monitoring working hours with changes to 0-hour workers coming down the line. It also makes sense to consider whether your HR systems have the capabilities you need to support this.
Yeah, that's great. Thank you so much, Kay. We've covered quite a lot in a short period of time, but the key messages I think to take away are make sure you have the resources in place, more than you think, sooner than you think. Make sure that you're conducting a really bespoke assessment of what the particular risks and strategic changes that you need to make within the organisation are, and make sure you have really strong project management as you roll it out. So it's hugely helpful for me to have you rolling this out for us at Bellevue Law. I'm full of confidence about how we're approaching this, and I hope it's equally helpful for our listeners to hear a little bit about how an employment law firm would go about implementing the changes coming out of the Employment Rights Act. Thank you very much indeed. In the next episode, our colleagues are going to be talking about the critical changes to the law on unfair dismissal that are going to come into force from the 1st of January 2027. That's the reduction of the length of qualifying service that you need to bring an unfair dismissal claim to 6 months, and the removal of the cap on compensation for unfair dismissal. These are critical changes for employers, and you need to be taking steps now to get ahead of them before they come into force in about a year's time. So please join us for that. And in the meantime, thank you very much for listening to this episode of the Bellevue Brief.